Greetings and welcome to Assessing Retirement Plan Compliance in a Post-Determination Letter World. At this time, all participants are in a listen-only mode. A question-and-answer session will follow the formal presentation. If anyone should require operator assistance during the conference, please press star 0 on your telephone keypad. As a reminder, this conference is being recorded. It is now my pleasure to introduce your host, Brenna Clark. Thank you, Ms. Clark. You may begin.
Good afternoon. My name is Brenna Clark, and joining me today is my colleague Meredith O'Leary. We'd like to welcome you to the Eversheds Sutherland Webcast, Assessing Retirement Plan Compliance in a Post-Determination Letter World. If you would like to receive CLE credit for this webcast, please download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions for submission. If you have any questions during the webcast, please submit them via the Ask a Question text box on your viewing console. We're going to be sending a follow-up email in the next day or so that will include a recording of the presentation and copies of the slides that you're seeing on your screen. So be on the lookout for that as well. In the meantime, if you'd like to request a copy of the slide deck, please feel free to reach out to either me or Meredith. Historically, the IRS has periodically issued determination letters to plan sponsors, verifying that their plan documents satisfy certain Internal Revenue Code requirements. These letters have provided comfort not only to plan sponsors, but also to related parties such as auditors, record keepers, lenders, and buyers in M&A transactions. However, in 2015, the IRS announced that it was significantly limiting its determination letter program, effective in 2017. As we start to shift away from this determination letter program, plan sponsors and other parties with an interest in qualified retirement plans should start reviewing their options for assessing and documenting plan compliance. So today, what we're going to talk about are a few of the issues that we're starting to see come up now that the IRS has announced that it's doing away with a portion of this determination letter program. So by way of background, let's talk about what determination letters are. Previously, plan sponsors would periodically submit their plan documents and any amendments that they might have made to their plan since the last determination letter to the IRS for basically a statement by the IRS that their plan documents complied with the Internal Revenue Code. Most recently, plan sponsors were doing this every 5 years. So every 5 years, plan sponsors were submitting their full plan document to the IRS. But in the past, other intervals have been used as well. It hasn't always been a 5-year cycle. Now, these determination letters are not required by the Internal Revenue Code. No plan sponsor is actually required to go out and get one. But almost all employers with an individually designed plan have historically gone out and gotten them. And in addition, a lot of employers who are on pre-approved plans have gone out and gotten these as well. And the reason for this is that what these letters are is they're basically an IRS blessing on the plan document, and so they give plan sponsors a certain level of comfort. If the IRS were to come in and audit your plan, as long as you have a determination letter, typically when the IRS was coming in and auditing your plan, they weren't looking at your plan document at all. They would see that you had this determination letter, and then they would move on, and they would look at other aspects of your operational compliance. It provided some audit protection there. Additionally, when you submitted your plan, if the IRS did find anything wrong with your plan document, and the IRS calls these disqualifying provisions, if the IRS happened to find one of those while it was reviewing your plan as part of the determination letter process, what the IRS would do, as long as the plan sponsor had acted in good faith, is it would typically allow you to go back and fix that disqualifying provision. And it would allow plan sponsors to do that without any sort of penalty. So essentially, it also provided some protection there as long as plan sponsors were acting in good faith. And of course, one thing to note about these determination letters, the IRS has never actually given any sort of an opinion or any sort of determination on how your plan is operating. These have always focused exclusively on your plan document and does your plan document say what it should under the Internal Revenue Code. So, of course, there are some limitations to the determination letter. It's never given an opinion on plan operations. But historically, these have been important for many reasons, and it's provided parties beyond just the plan sponsor with certain assurances about the plan document and whether or not it's qualified. When other parties have some sort of an interest in qualified plans, so you might see this as, in mergers and acquisitions, plan record keepers might have an interest in knowing that plans are qualified. A lot of times we will see lenders asking for certain representations about a plan's qualification, or you may be making representations as part of your pension investments, or as part of the 5500 audit process. All of these parties want some assurances that your plan is qualified, that it meets the requirements of the Internal Revenue Code. So these letters have historically been important for a lot of different reasons. It's not just the plan sponsors who have an interest in these. So what's changing? In 2015, the IRS came out and it announced that it was largely eliminating the determination letter program beginning in 2017. What the IRS said is that, essentially they were receiving these several hundred-page plan documents plus all of the amendments that went with them and all of the application materials that were included, and they were spending, maybe an average of 3 hours reviewing these applications. And then at the end of the day, they were coming out and saying, after 3 hours, they were providing basically a rubber stamp on your plan document. And the IRS has said that, it just no longer has the resources to do this. It felt like it was essentially giving employers sort of a get-out-of-jail-free card. It was, it was saying that the plan document was fine after just a very cursory review. And this is something that, it might take a law firm 10 or 20 times that to go through the plan document and give essentially the same sort of opinion that the IRS was giving. And so in 2015, the IRS came out and said, we're not going to do this anymore for most plans. And if you have a current determination letter now, what you can do is, a lot of these have an expiration date in the letter. And so the IRS has come out and said that it's fine to ignore that expiration date. And you can continue to rely on the determination letter that you have as long as the plan provisions are not amended or affected by changes in the law. So, for example, if you change your level of matching contributions or you change your profit-sharing contribution, you change your vesting schedule, then at that point you lose reliance on the plan with respect to those provisions. That new profit-sharing contribution that you've put in, you won't be able to say that you've gotten an IRS letter on that provision. And additionally, if there are subsequent changes in the law, then you won't be able to rely on your letter with respect to those provisions that are changing either. So this puts some plan sponsors at a little bit of a disadvantage. The last point that you could get a letter was in 2017. So we just submitted the last round of determination letters. But there are a lot of plan sponsors out there who last submitted their letters back in 2013 or 2014. And since then, they've made a lot of changes to their plan, just thinking that they'd have the opportunity to go ahead and get a new letter on those provisions, and that this program has gone away.
So I think, we've talked a little bit about what has changed, but I think it's also kind of important to note, what hasn't changed. So there will still be some categories of plans that can still get a determination letter, which creates some kind of interesting incentives that we'll talk about in this presentation as well. So, the first place where the IRS is keeping the determination letter process, again, as Brenna described, not required but permitted, would be for new plans and for terminating plans, the birth and the death of a plan. And what's kind of interesting with, and we'll talk about this a little bit further, but with the incentive that you can get a blessing on a new plan, or the situation that you can get a blessing on a new plan, that creates an incentive, to almost have multiple plans. And if you're kind of doing some creative plan designs, to almost set that up as a new plan and get a blessing on that, which is kind of interesting. The IRS has also said that there will be circumstances where there are issues the IRS identifies where they will be giving determination letters. They said essentially that, those kind of situations and issues would be coming out in the future. Nothing has come out on that at this point, so we don't have a lot of information about what kinds of situations they would think would be appropriate to, continue the determination letter program for. Perhaps the most impactful of the non-changes would be that pre-approved plans will still be getting determination letters, which obviously creates an incentive for people and plans to move to pre-approved plans, because those will still have a determination letter, that you can not only kind of rely on, but show to these third parties that are looking at it. For folks who are familiar with pre-approved plans, what those plans are basically form documents where you can kind of elect different provisions. You can make some minor changes to those and get a determination letter. If you make significant changes, it becomes harder to rely on that letter. And so one of the problems folks face is how to fit their scheme into the prototype document to the extent it's not a kind of simple, straightforward scheme. In terms of the things that are changing, the question becomes how will the IRS communicate, the changes in law. So there's a couple of different pieces of information that the IRS has said it will come out with, almost in lieu of this determination letter process. One thing that is staying the same is currently the IRS publishes a cumulative list each year. This describes the qualification changes that need to be included in the plan documents. The IRS is going to eliminate this list except for pre-approved plans. It is going to come out with two new kinds of documents. The first is the required amendment list, and the second is the operational compliance list. So the required amendment list reflects changes in qualification that are effective during a calendar year. It's going to be issued after October 1st of each year, and it's going to be more basic than the cumulative list has been historically. It is going to help employers know what rules they should be following before the required amendment must be adopted. So far, one of these has come out. This was published in February of 2017. It has two parts. It has a Part A and a Part B. Part A is applicable to kind of most or, all plan sponsors, and Part B is, kind of provisions that would maybe be applicable to some plans or plans with unusual plan provisions. What we saw with the first required amendment list is essentially there was only one item listed. It was listed in Part B. It was with respect to union plans. So far, based on what we've seen, that hasn't been a completely fulsome list, which may just be kind of, where we are in terms of changes of law. The operational compliance list is going to be a web-based list, so it probably, what we've heard is that it's not going to be necessarily a formal publication the way some, of the revenue procedures and other things have been. It's going to identify matters that may require amendments, and it's going to contain guidance on day-to-day compliance. It's not going to be totally comprehensive, so you can't look at that and, kind of go through those items and be sure that you're in operational compliance. But the idea from the IRS is that if you are kind of following those two documents, you should be in pretty good shape. One of the things we've heard is that, the IRS may be creating model amendments to help folks comply with the required amendment list if there are things on there, especially Part A, that would be required to be adopted. What is a problem from that perspective is just, how quickly the IRS can put those in place and whether plan sponsors, as a matter of course, will have already adopted, amendments by the time the IRS comes out with those.
So what we have seen are some questions about whether the amendment timing has changed. Historically, when the IRS has issued changes in the law, they've also issued various notices and guidance with deadlines for adopting amendments to reflect changes in the law. And, sometimes these have been sort of difficult to track down. They've been a little bit difficult to follow. But what the IRS has said is that with the elimination of the determination letter program, it's really trying to simplify the amendment process. So as Meredith said, each year it will post things to its required amendments list. And what the IRS has come out and said is that you're going to need to amend your plan by the end of the second calendar year that begins after the first required amendments list in which the change appears. So, for example, if we see something new that pops up on this 2017 required amendments list, then your plan document is going to need to be amended by 12/31 of 2019. So that should be a good change. It will be nice that sort of all of these rules are in one place, and you can go to one website, and it's very easy to see what amendments need to be adopted, and there will sort of be one fixed deadline for everyone. So I think that will be a positive change, and it will be a little bit more clear as far as when you have to amend your plan. For other disqualifying provisions, so again, these are things that if you amend your plan and it doesn't comply with the requirements of the code, you need to amend. It's the same, essentially the same amendment timing. You need to amend your plan by the end of the second calendar year following the year in which the amendment is adopted or effective, whichever is later. And the deadlines for discretionary amendments are going to remain the same. So as it stands right now, typically, if you make an operational change to your plan, for example, let's say if you have a 401k plan and you decide that you're going to allow plan loans, typically you can go ahead and put that amendment, operationally you can put that into place. You can start offering your plan loans as long as you amend your plan by the end of the plan year in which that change is adopted. And so that has not changed. That's going to continue. And then, there are some special timing rules for governmental plans, which we have now, as well as tax-exempt and new plans. Some other questions that we've seen come up are, what's changing as far as the employee plan compliance resolution system. So this is a program that the IRS has issued. Plan sponsors can come in and they can correct any errors that they find with their plan, and they can correct errors in the document, and they can also correct errors as far as plan operations go. And under the old rules, there were certain programs that were only available to you if you had a current determination letter. So if you wanted to fix something yourself, if you had an error that you did not want to bring to the IRS, you didn't want to bring to their attention, you just wanted to fix the error and move on. In order to do that in compliance with this employee plan compliance resolution system, you had to have a current determination letter. So obviously now that doesn't really work because no one will have current determination letters going forward. So the IRS has recognized that, and they've said you can continue to use this program even without a current determination letter program or a current determination letter. Under the IRS's voluntary correction program, so this was a program in which you would bring your error to the IRS, and they essentially bless your correction. Under this program, previously a lot of errors required a determination letter application as part of that program. So, if you had forgotten to make certain amendments, what the IRS would do is they would make you submit a determination letter application before it would accept your correction. So that has obviously gone away. Now you're no longer permitted to submit determination letters in connection with the voluntary correction program.
So the question, the big question I think for folks are, how do you address plan compliance now without the determination letter? Previously, like we've talked about, you had a certain level of comfort or almost a get-out-of-jail-free card with the IRS based on the determination letter application and letter you had received. What changes about, in the real world with this change in the process? The first and kind of most obvious change is that the burden of evaluating the plan document now shifts away from the IRS, who was previously doing this for a fairly, low fee, to the plan sponsor. And the question is, do you have the resources in-house to do that? Do you have to have somebody, an external counsel do that? But the burden of, kind of saying this plan complies has now shifted back. That includes kind of both the, the review of the document, the update of the document, and kind of the liability if in fact that decision is made and it turns out not to be the case. Like Brenna talked about earlier, one of the things that is helpful about the change is that, you will, as a plan sponsor, be able to rely on your existing determination letter to the extent you've received one, with respect to the provisions that the IRS has blessed until there is a change in law or you have changed the plan document. So to, kind of build on Brenna's previous example, if you have a plan document and you are changing, the matching or vesting provisions, you will be able to rely on the determination letter with respect to all of the provisions except that you have changed. So in the near term, I think there is not a huge impact of the program because, people are not going to, unless, they're going through kind of large changes, they're not going to be making big statutory changes in the next year or two. The question becomes, 5, 6, 7 years out when things change and when statutes change, how does that impact this? So, as this burden kind of shifts to the plan sponsor, obviously there will be an increased focus in doing a periodic review, again, either internally or externally. So, annually looking at the required amendment list and making sure that all of the, required updates are in there, looking at the operational compliance list and making sure that, operationally the plan is in fact doing what they should be doing. But kind of more than that, there's going to be essentially a burden on the plan sponsor to kind of go through the plan document and look at, what's changing, what's not changing, is there anything in there that has become a disqualifying provision, are there things that need to be changed to comply with law? And so, what we expect people to be doing is to be basically almost self-conducting that determination letter process in-house. What was previously outsourced to the IRS will now be essentially a responsibility of the plan sponsor. The natural result of that, we think, is that there will be, a somewhat, the plan sponsors will have an aversion to risk-taking that perhaps they would have done previously. One of the things that you were able to do when you submitted a determination letter is, to the extent you were designing a scheme that maybe was aggressive or maybe unusual, you could get some comfort from the IRS that they thought this was okay. Without that comfort, the natural response, we believe, will be likely to be, can we make this a more conservative provision, or a reluctance to put those things in because there's not going to be that comfort that is associated with the IRS letter.
One of the biggest questions that I think we're starting to see coming out of this is there is this question, well then, if the IRS is not issuing this letter blessing our plan document, then does it make sense to go out and get some sort of opinion letter from a law firm on our plan's qualification? And I think there has been a lot of talk about that. I think, there are some places out there that are starting to offer this as a very standard service. And it is just something that I think there's been a lot of discussion on And essentially what would happen is the law firm would take the place of the IRS. They would be going through, they would be doing a full review of the plan document, and then issuing something that probably looks similar to a determination letter, though I imagine, there may be some caveats to it as well. That says, yes, your plan still meets all of the qualification requirements. And so, this is just one thing that we're seeing. We're seeing a lot of questions come up, and I think one thing to note about this is that as Meredith mentioned, in the near term, it may not be all that necessary to get a legal opinion letter. You can still rely on your current determination letter with respect to any provisions that you haven't changed, and if you're not making any aggressive changes, if you're doing fairly plain vanilla changes to your plan document and you're not taking aggressive positions, then, at this point, I'm not sure that there will be a whole lot of value for a legal opinion letter in the very near-term future because you will still have that current determination letter. And you should be able to rely on it to a certain extent. Additionally, if the IRS does start issuing some more model amendments, then even as there are changes in the law, if you've got a current determination letter and all you're doing is adopting these model amendments that the IRS has issued, then again, I don't know that there are a lot of concerns that your plan isn't qualified. At that point, I don't know that it makes a lot of sense to get an opinion letter. And I think, additionally, you can certainly get different scopes of an opinion letter, right? In some instances, you may want to go out and get it on your entire plan document, but we think what we will see is that if you are doing something aggressive, if you're doing something complicated, if you're doing a really big change to something, then what you really might want is just an opinion letter on that particular amendment. You really may just want some comfort on that particular piece of things, which should cut down a little bit on cost as well. Now, as we move away from the determination letter program, as we go longer and longer without the IRS issuing these determination letters, and your plan starts to look less and less like the document that you got the letter for, then I think it is going to start to make sense to go out and get these opinion letters so that you get some comfort that your plan is still meeting the requirements of the law. And, the other thing that remains to be seen is, at this point, we just aren't sure when other parties are going to be asking for an opinion letter. In mergers and acquisitions, for example, one thing that remains to be seen is whether or not buyers are going to start actually asking for these opinion letters as part of the transaction. As your 5,500 auditors conduct their audits, we'll have to see, are they going to want some level of assurance? Are they going to want to see these opinion letters on the plan documents? Same thing with your third-party record keepers. So, that will be one thing that we'll have to monitor and see, and kind of see who's asking for these and in what circumstances. And, one of the things I just wanted to note about the opinion letters is, even if you go out and you get one and you have one of these on your plan document, the IRS can still come in and challenge your plan document provisions. When the IRS was issuing the determination letters, once they issued the letter, they would essentially say, okay, we're not going to question your plan document. But that won't be the case with the opinion letters. Now, certainly you'll have someone else on the hook if the IRS does question it, and they do want to assess some sort of penalties or something if they say that it's not meeting the requirements of the code. But there is still that possibility that the IRS can come in and challenge it. So with all the talk on the opinion letters, one of the things that we've wondered is, rather than going out and getting this very formal opinion letter, can you just create a new plan in certain situations? So, for example, if you have a transaction where you're possibly combining two plans, and the end result is that you're going to end up with a plan that looks very different from the two plans you have, rather than just merging the two plans together and continuing that existing plan. Can you go out and just get a new plan or create a new plan document, because you can still get a determination letter on those plan documents. It's sort of the same thing if you want to do a major design change of your plan. At a certain point, does it just make sense to create a new plan and go out and get a letter on that plan? So I think, what still remains to be seen is whether or not the IRS is going to issue any guidance on that, if they're going to come up with anything to sort of curb abuses there. But I think at this point, that is still one consideration if you're really doing some major changes to your plan. So some of the big questions that we're still seeing, will the IRS issue more model amendments for legal changes? We think that they will. They've given some sort of indication that they will. And I think, as we've talked about, this is certainly going to be helpful as far as reliance if they do. I just think that, one of the issues is historically they've been sort of slow to issue these model amendments. And by the time they issue the model amendments, I think a lot of plan sponsors have already gone ahead and amended their plan documents and started operating in accordance with changes in the law. So we'll see, if there are more model amendments coming down the pipe. I think, in the past couple of years, there haven't been a whole lot of legal changes. So, it's been a little while since we've seen a lot of model amendments. So we'll have to see what happens going forward. Another thing that has come up is whether or not plan sponsors will be allowed to just incorporate some of the legal requirements by reference into their plan documents. So right now, the IRS kind of frowns upon just incorporating a whole section of the Internal Revenue Code into your plan document. You cannot just say, your plan document cannot just say, we're going to operate in accordance with X section of the code. What the IRS really wants you to do is they want you to spell out exactly how you're going to comply with X section of the code. So it may be that in order to make these plan documents a little simpler, in order to make the compliance process a little bit easier, we may see more guidance allowing plan sponsors to just, kind of incorporate by reference these kind of more formal code requirements. Another thing that remains to be seen, right now, there is no way to correct plan document errors without taking it to the IRS's Voluntary Correction Program, that VCP program, and disclosing it to the IRS and getting the IRS to approve your correction. There is just no mechanism to self-correct these document errors. So one thing that might be very helpful is if some new guidance is issued that allows plan sponsors to catch these types of errors on their own and correct maybe minor errors themselves, and then just document the correction and move on. What remains to be seen, is how closely the IRS is going to review these plan documents on audit. Historically, when the IRS has come in and audited your plan, I think what we have seen is that there has been a huge focus on operational compliance. Historically, the IRS will come in, they'll say we're auditing your plan, and they will ask for the determination letter. They'll ask for a copy of the plan document. But as long as you provide those two items, at that point they sort of drop the issue and they start looking at all of the operational compliance. So now that the determination letter is going away, it will be interesting to see sort of how closely the IRS is looking at your plan document on audit, because that is just one thing that we have not seen before. And additionally, what will the penalties look like if documents are discovered? As I said, historically there just hasn't been a lot of focus on the plan document and the audit process. So, it remains to be seen how strict the IRS is going to be on this.
For those of you who would like to receive CLE credit for today's webcast, our confirmation code is determination with a capital D. Please use this code for the sign-in sheet available for download from your viewing console. So with that slight interruption, we'll go back to the presentation. So one of the things I think we've kind of talked about in this presentation a little bit is the fact that the pre-approved plans will still have these determination letters or opinion letters, and because of that advantage, is there an incentive or a reason to move from an individually designed plan to a pre-approved plan? Some good things about pre-approved plans are, if you do not make too many changes to kind of the form document, you can rely on the opinion letter there. And as we've kind of talked about, kind of throughout this presentation, that has value both in terms of going back to the IRS and being able to say this document is blessed, and we don't, there's nothing to see here, no ability to kind of come back and say it doesn't comply. There's obviously those third-party issues we discussed. So, if you're in an M&A transaction, you can give comfort or receive comfort. If you have auditors asking for it, if you have third-party providers, you can, hand them a piece of paper that looks like something they're used to seeing in the past that gives them the comfort they're looking for there. One of the other benefits is that the document provider can also often handle the legally required changes, usually without too much action, if any, on the plan sponsor's part. One of the services you are kind of paying for when you go to a pre-approved plan is basically that they will be updating the plan document and going through that approval process, so that if there are year-end amendments, they will have those ready. They will be providing those to you. That being said, one thing we've seen in practice is sometimes, depending on contact information and other things, those can get lost in the process. So even if you are using a pre-approved plan, you probably still want to, ping them every year to make sure that if there is anything, you've gotten those, you've signed those, you have copies of them. A lot of times we see the pre-approved plan documents, being provided by a third party or kind of working well with a third party provider's record keeping system, because they tend to be, fairly straightforward and, I don't know what the right word is, but not individually designed, not complicated, I don't want to use the word simplistic, but straightforward is probably the right word. There are fewer potential record keeping errors because they're usually lined up in a way that they can, work with a record keeper's system pretty well. And you could also still obtain a determination letter every 6 years if you're making minor changes to the pre-approved document. So some things that we've seen here are if you are using a, kind of a matching scheme that maybe isn't exactly like the plan document but is very, very close, you can sometimes, depending on how close it is, say, this is very, very close to what is in the plan document, but it's not exact, and I want to get this blessed. This is a minor change, not a major change, and it should fit within this pre-approved plan document letter. So what are some of the downsides to these pre-approved plans? The greatest strengths are its greatest weaknesses, right? So, one of the things is that these plans are very straightforward. They're designed to work for a majority of plan sponsors, but they might not work for you, especially if you have an individual scheme that is complicated. It might not work for you if you have a fairly large plan where you have different populations receiving different benefits. It might not work for you if you have legacy folks. So, what we tend to see is a lot of our very big employers have individually designed plans that are fairly complicated, in part because they're covering huge numbers of employees in different circumstances that have come in and out of the population at different times, and that maybe have different, compensation schemes that need to be addressed. That is the downside of a pre-approved plan, is that it's harder to kind of do those different schemes or those complicated schemes within something that's really not designed for that. So, and obviously the further you get away from the prototype plan, the less likely or the inability you have to rely on that opinion letter. The IRS has requested some comments on this issue. If there is a way that people have suggestions to make, to incorporate this, whether it's by multiple schedules or something like that. I don't think we've seen much at this point because this is fairly new guidance coming out from the IRS. I don't think that, much has been said about this at this point. Another downside to the pre-approved plans is there's a potentially strict amendment process. So, again, like we've talked about, when the year-end amendments come out, you're gonna probably have to use a particular form used by the document provider if you want to make tweaks to it or you want to, stray in some way. That's going to be harder to do and rely on the letter. The places that pre-approved plans tend to work best tends to be on defined contribution 401k plans. That's just tending to be where they've come out and where they've worked best. They have, there's kind of limited capabilities for defined benefit plans, ESOPs, or plans with complicated historical provisions. Just there doesn't seem to be a ton out there on those, and the forms don't tend to lend themselves readily to those situations. So some other considerations with pre-approved plans, I think clearly the IRS is expecting more employers to move to pre-approved plans. I think that's certainly Eversheds Sutherland's view and what we expect to happen. The good thing coming out of, or one of the good things coming out of the IRS guidance is that they have said that, as a result of that, they are trying to simplify the pre-approved plan process. They've recently issued some guidance making modest changes to the pre-approval program. There was previously a distinction between kind of volume submitter plans and prototype plans that wasn't totally sensical, and they've eliminated that distinction. They've also have said that they want to make it easier for law firms and other third-party providers to submit pre-approved plan documents to the IRS. So they are clearly trying to give plan sponsors an avenue to kind of get some comfort and move to this system if that system would work for them. Obviously, as plan sponsors consider whether moving to a pre-approved plan, whether that would make sense for them, there will have to be kind of a careful review on that conversion. If the provisions don't match up identically or nearly identically, how do you change the provisions? Does that match with how you're complying with things, with how you're operating things? Will that require changes to, kind of what your population views as the substance of their plan, the vesting and the matching and things like that could also have impacts on them.
We've talked a lot today about the plan document and how exactly you can go about documenting your plan documents compliance with the Internal Revenue Code. But, I think that one thing it's important to be aware of is that in order for plan sponsors to take advantage of all of the tax benefits with these qualified plans, there are really two pieces to compliance. You've got your plan document, and so that has to satisfy a whole set of requirements, and that's what the determination letter program is all about. But the other piece of this, to maintain your plan qualification, one of the requirements is that you have to be operating in accordance with that plan document. You have to be operating in accordance with all of the Internal Revenue Code's provisions. And with resources moving away from the determination letter program, some believe that what will come out of that is there may be more IRS audits coming out of that. We may see increased audit activity, and this is going to impact all plan sponsors. Whether you're on a pre-approved plan, whether you have a current determination letter that you can rely on, or whether you've gone out and obtained this legal opinion letter, I think sort of all plan sponsors have the potential to be audited. And when your plan is selected for audit, the IRS can come in and they can take a look at your plan document, and they can also look at what you're doing operationally. Are you following the terms of your plan document? Are you doing what you're supposed to and what the code says? So with the elimination of a large part of the determination letter program, what we're thinking is we may see an increased focus on operational compliance here. So what would the IRS be looking for if that happens? There are a couple of kind of hot topic areas that we see over and over again in plan audits. In addition, the IRS has said that it's going to be producing this operational compliance list each year, and that might provide some insight as to sort of the issues that it thinks are important. But kind of the ones that we see over and over and over again are required minimum distributions. Once you reach age 70 and a half, your plan has to start paying out a certain level of benefits to participants. So this has been a huge one, and we see this come up all the time, and in particular with pension plans, it's a big issue. And in fact, it's not just the IRS that's looking at this; it's also the Department of Labor that's looking at required minimum distributions. They want to know that you're reaching out to your participants. They want to know that you're paying them their benefits because the IRS wants the taxes on those distributions. So they're looking to see that you're doing this. They want to see how you're going out and finding lost people. So that is one that we are seeing come up over and over and over again. This required minimum distribution issue. Some other issues that we see. Does your plan definition of compensation match what you're doing? One thing that we find is very helpful is to go through all of your various payroll codes and look at what you're including as in your plan definition of compensation and what you're excluding. And does that match what your plan document says? Because there can be definitely some pretty big issues there if you're not using the correct definition of compensation. Another thing that we've seen a lot of focus on in these audits is non-discrimination testing. With a 401k plan, are you doing your ADP testing correctly, your ACP testing correctly? And those are just various tests to make sure that your highly paid people are not getting better benefits than your lower paid people. And I think that one reaction we commonly see to this is when we ask about non-discrimination testing, the employers may say, well, our record keeper handles all of that for us. And that's very true. The record keepers are definitely running all of the tests. But one thing to keep in mind is that, it's very important to be providing the record keeper the correct data. If they're not getting the correct data, then they cannot run the plans correctly. And so that, that's just one thing to be on the lookout for as well. We're also seeing a lot of questions about eligibility. Are you notifying people that they're eligible for the plan on time? Are you getting them enrolled in the plan? A lot of plans have put auto-enrollment schemes into place. So are you following that? Are you putting people into the plan and giving them the matching contributions that they should be getting? We definitely see a lot of issues with that as well. Additionally, one thing that we see come up over and over again, and I've seen a lot of IRS focus on it, is how are you operating your plan loans and other in-service withdrawals? I think that plan loans are something that they get messed up all the time. It's one of the most common errors that we see. Probably the biggest thing is, participants just don't repay their loans on time. A lot of times, you'll set up an automatic payroll deduction for your loan, and participants are not paying attention to their paychecks, and you may go 6 months and a participant isn't repaying his loan. And so under the terms of the Internal Revenue Code, that means their loan's gone into default, and and you should be taxing them on the value of that loan. So that's just one thing that we see come up over and over again, are loan errors. And, just kind of the last thing here are contribution and benefit limits. The Internal Revenue Code has certain limits. For example, under a plan, you can only take a certain level of compensation into account. Let's say you're making a matching contribution of 10%. I think that's probably a very generous match, but let's say you're doing a match of 10%. then, if you've got somebody who's making $500,000, you can only consider the first $270,000 of their compensation. So if you're doing a 10% match, you're never going to give these employees more than $27,000 in matching contributions. So, there's a lot of focus on whether or not you're complying with those, whether you're keeping participants below the 402G limit, which is that $18,000 employee deferral limit. And, also there are some limits on just the total amount of contributions that you can make to a plan. And also there are similar limits that apply to pension plans as well. So those are some of the issues that we're seeing come up as far as operational compliance, and that we expect to see more of a focus on. And so, as there is this increased focus on operational compliance, one of the things that we think is probably going to be beneficial for plan sponsors to do is to start reviewing these common compliance issues. Are you using the right definition of compensation? Are you starting your required minimum distributions? Are you operating your loans correctly? And so that you can catch things and address your errors up front. And, I think the benefits to this, of course, are twofold. First, the sooner that you catch errors, the less expensive that they will be. It's always cheaper to correct errors that have been going on for 3 months versus 3 years. So that's one benefit. And then, obviously, you want to discover errors first. You want to discover them before the IRS comes in and audits you and discovers them. It's of course, much cheaper to correct those errors if you catch them first. And, I think as we've talked a little bit about today, there are a couple of different avenues that the IRS has for correcting these errors. There's the voluntary correction program, where you disclose errors to the IRS and the IRS formally blesses your correction. We're thinking that the IRS is expecting to see more. They're encouraging more of these voluntary filings. This year what they did is they reduced the fees for these. I think in the past, for very large employers, the sort of top level, the top fee to participate in the voluntary correction program was about $25,000. That's been reduced. Now it's at $15,000. So they're reducing costs across the board and making it easier to do these types of filings. And additionally, for some of those more common errors that we've talked about, like the loan failures and the required minimum distributions, the fees to correct those can be even lower. So for example, if you've got a failure with your plan loan, depending on the number of impacted participants, that fee, instead of $15,000, the fee to submit a voluntary correction program submission would be somewhere between $300 and $3,000. And we're seeing the same thing for required minimum distributions. If you've got fewer than 150 participants, then you can correct that for as low as $500. If you've got fewer than 300 participants who are impacted, you can do it for $1,500. So it really is getting easier to correct these sort of errors and do these VCP submissions. And then, of course, you can always self-correct. You can always self-correct errors as well. What the IRS has said is there are some conditions on your ability to self-correct errors. What they really intend this to be for is insignificant errors or errors that have only been going on for a brief period of time. But there is that ability to self-correct certain errors as well. And there, if you're catching errors and you're self-correcting them, then I think it's just important to make sure that you're documenting the correction. You want to put that memo in the file saying, we found an error, we caught it, here is how we corrected it. So that, in the event that you ever are questioned about it, you've got some sort of record of that.
So I think as we've touched on, a little bit in this presentation, there are obviously concerns that you have with the determination letter process going away as a plan sponsor, but there are also some kind of additional considerations that may come up in terms of corporate transactions. obviously if you are buying or selling a company or merging a company, one of the issues that comes up with qualified plans is, the comfort that this plan document is qualified and also that this plan has been operated in compliance with the IRS and Department of Labor laws and rules. So, obviously the compliance aspect will not be changing. That will still be a concern. The determination letter process never really impacted that. But, in terms of the plan document, things that you will be concerned with, whether you're kind of buyer, seller, target or not, will be how old the determination letter is. I think as Brenna touched on earlier, there are some plans that last submitted for a determination letter in 2013, and so they will have more significant changes than those who submitted for a determination letter in 2017. There will be, more changes to the plan since the determination letter. The other issue that, you would want to be concerned about kind of either as buyer or seller will be, what changes have been made and how easily can you show what changes have been made. Because remember, if you have a determination letter, you can rely on that determination letter to the extent those provisions have not been changed. So if you are a seller, you will want to be able to show to a buyer, look, here are 2 provisions that changed and you don't really have to worry about that versus, here is a whole bunch of provisions that have changed. You'll want to make that clear on both sides. And I'll talk fast through this since we're coming towards the end of our time, so I'll kind of speed through this. But if you have questions, definitely feel free to talk about them with us later. But wanting to check and make sure the plan sponsors kept up with the required amendment list, wanting to check in on all those operational issues that Brenna discussed earlier that you would normally check in with on your corporate due diligence, that are going to come up regardless of a determination letter. And so the big question in this area is, if you're a seller or a buyer, should you be asking the seller to provide a legal opinion letter on the plan qualification? And to the extent that that's not going to happen in the transaction, is there some other avenue to provide protection? The most obvious one being indemnification, that to the extent the plan is not qualified, having some other protection out there, in terms of indemnification. Realistically, I think, at least my opinion is that I don't know that with the speed that some of these transactions move, that to the extent you didn't already have a legal opinion letter, you would really be able to get it done in time for a transaction. If you think of some of the, faster moving transactions happening in, 6 to 8 weeks for signing, not totally clear to me that you could get a full legal review of a plan kind of within that time, especially if you're maybe having it done by the same team that's also doing your corporate transaction, which then to me raises the question of, is there a value in having those opinions, having them updated every year so that you have them ready to go if you have, a corporate transaction. And obviously, the concern there is either if you are taking on as a buyer the liability for the plan, you want to make sure it's in compliance, or to the extent you're taking rollovers from a plan, you want to make sure that plan is qualified so it's not tainting your plan. So kind of speeding along to our next concern in corporate transactions would be, generally what's fairly market now in terms of representations for a seller is that any qualified plan has a current determination letter or opinion letter, and that nothing has occurred that could reasonably be expected to result in the disqualification of a plan. Obviously, there are going to have to be some changes to that, that maybe they have a determination letter, maybe they don't, we may think about whether it makes sense to expand on that typical representation, to the extent that they have made all of those amendments that were required, or they have not made any amendments that are reasonably expected to impact plan qualification, that they've been keeping up with that operational compliance list, that the amendments have been timely made, and kind of enhanced legal compliance representations with the concern that people are, that the potential is that the IRS is moving towards audit of more plans with the focus, perhaps being on the plan documents in a way they have not historically been. And so again, that just comes back to the question of, is the market going to be asking for a legal opinion letter as a condition of the transaction? Are people going to indemnify each other for failures of plans, or, is there just going to be kind of an assumption of risk on either side? And at this point, we don't have a great sense of kind of the approach that most people will take in the market because this is still fairly new.
So, I know that we're just about out of time, but we did get one particularly interesting question that I think it makes a little bit of sense to talk about. Somebody has asked, should we even be concerned about this in light of the tax code overhaul planned by Congress? And so, obviously, we don't know what's going to happen in the future, but I think one of the things that did come out of this most recent framework that came out yesterday is that there is this concept that, the government wants to make it easier for people to save for retirement, which to me suggests that, these vehicles for savings are going to continue. We're still going to have qualified plans. There's still going to be a desire to allow employees and plan sponsors to put money away on a tax-free basis. So, while the requirements may look a little bit different, I would still expect that these qualified plans will continue, that there are going to be, certain requirements that you have to meet for them, that you're still going to need a plan document. That plan document is still going to have to comply with certain aspects of the Internal Revenue Code. So, while those requirements might look a little bit different, I think this will still be an issue going forward. So I think with that, we are out of time. So I'd just like to thank everyone for joining us today. As a reminder, if you'd like to receive CLE credit for this webcast, please download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions for submission. If you missed the code, it's determination with a capital D. So again, that's determination with a capital D. And if you have any questions or you'd like to request a copy of the slides, just feel free to reach out to one of us. Thank you.
This does conclude today's webcast. Thank you for your participation. You may disconnect your lines at this time, and have a wonderful day.